So, we'll discuss the question and its relevant answer. Question number 32. That is, explain the doctrine of clog on redemption and state the basis of the doctrine. The very answer regarding this question, as we found under section 60 of the Transfer of Property Act 1882, and what exactly clog on redemption means. The right of redemption is the fundamental characteristics of mortgage. Yes, the right of redemption continues although the mortgagor fails to pay the debt at due date. It is a right which cannot be fitted by any condition which impedes or prevents redemption. Any such condition is void as a clog. As example, implement on redemption. The right of redemption of the mortgagor has been the subject of anxious protection in law, so much so that an impediment to the fair exercise of the right, as for example, a clog on the equity of redemption even by a contract of the parties at the time of the transaction, is not recognized by the Indian legislature. In this section, section 60 has omitted the words in the absence of a contract to the contrary, with a view to prevent the mortgagor from contracting himself out of his right of redemption at the time of the mortgage. So, the very ruling of Justice Amon Lindley in the leading case, Biggs versus Hadinot in 1898, in this English leading case, express this section is unqualified in its terms and contains no saving provision as other sections do in favor of contracts to the contrary. So a mortgage is regarded as security for money, and the mortgagor can always redeem on payment of principal, interest, and costs, and any bargain preventing such redemption is void, nor will unconscionable bargain be enforced. There is no case where collateral advantages have been disallowed which does not come under one of these two heads, as it was decided by Justice Amor Lindley in Biggs versus Hodinot's case in 1898 as Justice Chancellor. So, in other words, an agreement which prevents redemption and an agreement which imposed upon the mortgagor an unconscionable or oppressive bargain is void. We are here for the moment concerned with the first one, as for example, an agreement which prevents or clogs redemption, since the object of a mortgage is merely to afford security to a lender. It follows that any contract which directly or indirectly prevents the recovery by the mortgagor of his property upon the performance of the obligation for which the mortgage was given as security, is inconsistent with the very nature of the transaction. For upon such performance being complete, there is no longer any need or justification for the retention of the security. On grounds, therefore, of logic as well as of justice, the courts have consistently held void any contract which, in this sense, is repugnant to the nature of a mortgage transaction, as Justice Romer of the Court of Appeal in 1904 in a leading case held that now there is a principle which I will accept without any qualification, that on a mortgage you cannot, by contract between the mortgagor and mortgagee, clog, as it is termed, the equity of redemption, so as to prevent the mortgagor from redeeming on payment of principal, interest, and cost, as it was declared by Justice Romer in 1904 in a case in Court of Appeal. And now we'll go to some other important instances of clogs. One is condition of sale in default, then a condition restraining alienation during mortgage, and the third is a condition to grant permanent lease to the mortgagee is a clog, and the fourth one, the condition extending beyond redemption, and the fifth one, postponement of redemption for unduly for long period, and the sixth one, delay in payment or default will lead to penalty, charged penalty. Then seventh one, redemption restricted to mortgagor. So the first one, the first instance of clog is condition of sale in default. So a condition converting mortgage into a sale and thereby extinguishing the right of redemption is invalid. Thus, a condition, if we do not pay your amount by the due date, we agree to this document being treated as a sale deed, was held to be a clog. Similarly, an agreement which renders part of the mortgaged property absolutely indemnable is void. And the second condition, that a condition restraining alienation during mortgage, thus a condition that a mortgagor shall not alienate the property during the continuance of the mortgage is invalid, because it would prevent the mortgagor from raising money to pay off the mortgage debt. And the third instance of clog is a condition to grant permanent lease to the mortgagee is also a clog. And the fourth instance of clog is condition extending beyond redemption, an agreement by the mortgagor who was a tenant of a public house under a lease which had 26 years to run. that for the whole of the remainder of the lease he would sell no beer on the premises except what was but from the mortgagees was held to be a clog. Had the agreement been limited to the duration of the mortgage, as for example until actual redemption, it would have been valid as it was held in the leading case. No case versus Rice in 2009 in a case of Court of Appeal. And now we'll go to the fifth one, that is postponement of redemption by unduly long period. So in that connection we will discuss the ruling of the leading case Sher Khan versus Seth Swami Dayal in 1922. The Privy Council pronounced that the mortgage did beyond that, provided that the mortgagor was to redeem at end of 5 years, and in case he felt the mortgagee was to have the possession for a period of 12 years, during which the mortgagor could not redeem. It was held by the Privy Council that the condition was a clog. And in the same way, in another leading case, Dwarika Mathur versus State in 1980, Patna High Court held that long term for redemption does not amount to clog on redemption. And now we'll go to the sixth one, that is penalty in case of default. So a stipulation to charge enhanced rate of interest from the date of mortgage in case of default in payment has been held to be a clog. But if there is no undue influence, a high rate of interest is not necessarily a clog. And now we'll go to the last instance, that is the seventh one, redemption restricted to mortgagor. An agreement that redemption should be available to the mortgagor and not to his heirs has been held as a clog. And now we'll go to another portion, that is what is not a clog. In that connection we'll discuss the first one, that is sale subsequent to mortgage, and in that connection we'll discuss one illustration. So sale subsequent to mortgage, we have noted above that a condition of sale is a clog if it is a part and parcel of the mortgage transaction, but subsequent to the mortgage, the mortgagor may agree to sell the property to the mortgagee. As regarding the very illustration, a mortgage is house to be with possession for 10 years. But 6 years after the mortgage agreed to sell his house to be, this agreement being subsequent to the mortgage and standing apart from the transaction is valid and it is not a clog. So now we'll go to the second one, that is high rate of interest is not necessarily a clog. And the third one, that is a condition of payment of remuneration to the mortgage is not a clog, as we found, for example, when the mortgagee acts as manager of a big mill, is not a clog, as he is receiving payment of remuneration as manager besides a mortgagee. And the fourth condition that we found, which should not be a clog, is granting lease. So a condition of granting lease which lasts for during the continuance of the mortgage, for example, until actual payment, is not a clog. So in this question we have analyzed exactly the very doctrine of clog on redemption as it is provided under section 60 of the Transfer of Property Act. So in relation to that, we have analyzed two important English leading cases. One is Biggs versus Ordinance in 1898. The judgment was delivered by Justice M.R. Lindley, and also the very opinion expressed by Justice Romer in 1904 in a case decided in the Court of Appeal, and the various instances of clogs of redemption, such as condition of sale in default or a condition restraining alienation during mortgage, also a condition to grant permanent lease to the mortgagee, and also condition extending beyond redemption, and the fifth one, postponement of redemption of unduly long period, and the sixth one, delay in payment or default, which would be a penalty charge, and all the seventh one, redemption restricted to mortgage. All these instances are examples of clogs on redemption, and which we discuss with some important leading cases relating to such instances of clogs, such as No Case versus Rice in 1902, decided by the Court of Appeal, and also Sherkham versus Seth Swami Dayal, decided by the Privy Council 1922, also Dwarika Mathur versus State in 1980, decided by the Patna High Court, and lastly we discussed about certain circumstances or condition when it would not amount to clogs, such as sale subsequent to mortgage, high rate of interest, and the payment of remuneration to the mortgagee, and also granting lease, which would not be considered as clog on redemption. So this would be the correct and appropriate and exact answer to this question. Question number 32. Explain the doctrine of clog on redemption and state the basis of the doctrine. And in our upcoming video, we will discuss those portions that we have left regarding the President of India and in relation to impeachment and his judicial powers.